of the large expanse, the latitude given to judges to bring contempt proceedings against persons who in their view, have scandalized the courts. That is why, as we speak, in the UK, where we inherited our common law contempt has been reduced into statute. And I think that in the development of our democracy, judges and the courts must open themselves to constructive criticism.
Right, so you heard Dr. Ayine in there, particularly speaking at that panel discussion which has led to this situation. And of course, you also heard Honorable Fuseni in there giving his remarks or thoughts about the letter referring Dr. Ayine to the GLC by the Chief Justice. Once again, you're welcome.
Thank you.
It's good to have you. So, coincidentally, you were on that panel discussion.
That's
so
right.
You heard it right as it came out of Dr. Ayine's mouth. And subsequently, you've had also cause to give your reaction to that. Now, let's understand exactly what about the statements made by Dr. Ayine is found to be offensive to the judiciary.
Thank you very much and good morning. Yes, as you rightly said, I was part of the panel that were chosen to review the Supreme Court petition, the presidential petition, together with, I think, 4 or so other persons, 2 from out of the country, I think Kenya and Uganda, if I'm right. Later, other people also joined, Sheshe Akutuampao joined, and a few others also. And we had a very healthy discussion, including, I think, Mami Mensa Bonsu so as well. And let's put it on record that I think we all spoke approximately 20 minutes or so in total. And I had to react almost contemporaneously when an aspect of what Dr. Ayine said, in my view, was quite offensive. None of us reacted to any other part of what he has said. So it is not as if everything he said was offensive to me or scandalous.
So what was that thing?
It was the aspect, and I don't want to quote, but I think it bordered on whether the judges that sat on the presidential election petition case had a mind of their own, and that they were not independent. It really hit me, and just before I had realized, I had told him, you are out of order, you are completely out of order. On the program, yes. Right. Contemporaneously, I said that. And Mami Mensa Bonsu also questioned him, and even the host asked him to give specific instances. So I asked, so first of all, it means somebody was controlling them. Who was that person? It means they are not independent of what they were doing, which means they were dependent on someone or some people. And it was important to point out these to substantiate your point.
Is that when he went into to talk about the fact that there were lack of reasons given for the refusal and dismissal of applications and all?
Yes, those things preceded this last statement.
Okay, so he laid a foundation.
Yes, he laid a foundation. Okay. I mean, there's no doubt about that. And so it is for those who appear to be agitated, is their right anyway. And it's as if judges now don't like to be criticized. That has not been the case at all. Because all of us critiqued the judgment. I mean, H. Prempe, you know him, Professor Asari was also on the program. If I got to a time, I think Professor Asari even disagreed with Dr. Ayine on some other matters about how, I mean, the conduct of the proceedings. But it was just that aspect, and he appeared to highlight it a bit more. Indeed, just before we ended, I told him that if he found my reaction also offensive, he should forgive me. But I think it was just contemporaneous, and I still stood by by it, and I still stand by it that perhaps he should have put it differently. But of course, somebody will say, "Who am I?" But the point really is that knowing who Dr. Ayine is, and when I was listing lawyers who have had influence on me in my book, I mentioned him, and so we have all looked up to him in terms of the practice. One of the finest you can get, one of the finest deputy attorney generals. I mean, he stands to give a speech, and you really feel that a lot of research has gone into it. But on this occasion, I think that he erred. And I believe that if he is given the opportunity again right now, he will never repeat those words.
I saw an article that was written, and you had made that statement that you feel.
I strongly believe that.
Subsequently, you haven't had any discussions with him?
No, not yet. I wanted the dust to settle a bit. But I strongly believe that he will never repeat those words. Right.
Now let's look at this. It looks like there's a lot of people who are of the opinion that perhaps this is an attempt to, as it were, quote unquote, gag people from, speaking out. Why do you think there's that level of sentiment, in that direction?
Well, people are truly free to express their view, but as I'm saying, throughout the program, which lasted in excess of 1 hour, none of what all of us said has become the subject of this invitation. Not even 90% of what Dr. Ayine said is the subject of this invitation. It is that particular aspect. That's why I say that perhaps, in all fairness, if he's given another opportunity, he will retract it. But, you see, as for criticism, judges themselves welcome it. And if you permit me, my favorite quote from Republic versus Mensa Bonsu, and I'll go a bit further just in a few minutes. And this is Justice Adade. I would wish to caution that we all, the lay public, the legal profession, and the judges themselves have a stake in upholding the integrity, authority, and respect of and for the judiciary. If this should collapse, one of the surest foundations of our democracy would have vanished. And we shall all be the poorer for it. And he goes on to say, of course, judges, like any other group of human beings, do make mistakes and should and indeed ought to be criticized. At times, some of us feel that our judgments are not being criticized enough, especially by the legal profession. I expect, however, that the language of criticism will be tempered and measured. It is not often remembered that judges, seen by many as very strong, are in fact the weakest members in the society. We receive blows. We cannot throw any. A factor to be taken into account when a member of the public is inclined to criticize us.
Right, it goes on and on and on and on, but essentially the point is made.
And this has always been true in 1995, 96 when it was said, and even more so today. Right. And I said that the moment a decision is given to your client and he instructs you to appeal, and you do appeal, or you go up for certiorari to quash the decision, you are criticizing the judgment. And so nobody, especially judges, have never been averse to criticism or criticism of their decisions.
Right. After a judgment is made, definitely that stays is there. But let's look at this. Is it to say, because reading from this and in your earlier submissions, the impression is that the judiciary has a certain place in society.
That's right.
And the more confidence we put in that institution, the better. But it can't also be the case that if indeed there are questions, real questions to be answered about its seeming non-independent status, that too, it doesn't mean that we cannot talk about that.
Yes, obviously you can. And But if in doing so you impugn their integrity, or you use language that may be tended to impugn their integrity, that, as has even been repeated here, is what may be offensive. But let's also put it in context. The invitation, I mean, I always say that if you are an active practitioner and you have not yet received an invitation to a disciplinary committee, you can expect one in your lifetime. I mean, and people go there. There had been earlier publication of 3 of our colleagues who had actually been invited based on some comments they also made on the presidential election petition. And they were either acquitted, well, let's say a petition was put in for them or a plea was put in for them, and I think they were cautioned and asked to go. So it's not as if it's a place where it's a Sahindrin where you go and you are deemed guilty before you even appear. So the language used in the notice is alleged to have made this statement. So, but I think, again, knowing who Dr. Ayine is, he may take steps that may in a way show that perhaps that statement shouldn't have been made. I mean, he did the same thing.
But perhaps he believes in that statement because he, like we've already, you know, I mean, Jifa in that interview brought that up, that this was something he said when the petition was, you know, being heard. Cited for contempt, ordered to purge, which he did. Then subsequently, he makes that statement. That's quite consistent, and that perhaps speaks to something that he's convinced about, don't you think so?
There's a point in that, but the fact that he also withdrew the earlier statement and apologized also means that perhaps he did not seriously believe in that viewpoint. Otherwise, he wouldn't have apologized and he would have suffered the penalty for it on his honor. Yes, it has been repeated. Perhaps is almost to say to err is human. But I wait to see whether in this particular circumstance he may want to stand by it and defend it.
Will the context matter in that in the first instance the matter was sub judice, so perhaps there was a certain urge that, well, I should, you know, we all know that when a matter is, you know, being heard or still being adjudicated, you're careful, you don't say things that could prejudice the outcome or not. But post the hearing, some would say, well, this is perhaps an academic exercise, an intellectual exercise he's engaging in. He can speak freely, and if he's not allowed to, he's being summoned to the GLC, then that is a red flag being raised, and people henceforth are not even going to freely critique judgments or proceedings that are over and all of that.
Well, that's a point that people can make, but unfortunately, I disagree. My point is that, as I told you, I mean, we were on the program, spoke at length, critiqued the decision. A lot offered some recommendations as to what should be done. I mean, Professor H. Prempe went at length to list certain recommendations for future, if you like, guidance, or let's see if the authorities will adopt it. So it is not about criticisms, as I'm saying, but a criticism that may be seen or deemed to impugn the integrity of the judiciary. That is the point that I believe this whole matter is about. And no one is passing judgment. That's why he's been invited for allegedly making that statement. But because of what my own immediate reaction, which I think I still stand by, that it was better those words, particular words, were not used. I'm not the one to suggest how he should choose his language, but I am saying that knowing my own Dr. Ayine, I've known him quite a bit. I mean, he can say in public the role some of us played in law when the other matter came up. And we stood by him, and it went past. So I think that he will not repeat that.
If given the opportunity.
He may have been in the heat of the moment. That may be one argument, but as you pointed out, or some have pointed out, Maybe it's twice too many. But the other opposite to is right. Perhaps in the heat of speaking, we all err sometimes. But I think that as he did for the first one, if it's something that is consistent with what I think about him, his nature, his demeanor, general disposition towards everyone, his respect for even younger ones. And I had cause to wonder why the younger or some of us coming up haven't really picked up some of his fine disposition. I mean, he's a fine man.
Right.
But on this occasion, I'm saying that he may agree with me that it wasn't appropriate.
Very well. Now let's look at the referral. Do you think this reaction is coming in because it was a referral by the CJ? Had it been any other person, do you think would have had this level of, it may be a bit speculative, but I think it's worth interrogating. And we'll go into the composition of the General Legal Council. Perhaps that is why people are raising these concerns. Do you think it would have been any different if it had come from any other person, maybe any other lawyer or somebody but the CJ?
But the often is it came from the office of the Chief Justice, is the Judicial Secretary's hand, which is
saying that the
which
Chief
appears
Justice has,
on it.
yes.
Yeah. So, and it's not unusual. I mean, people can testify to the fact that this is not the first time office of the Chief Justice has sold somebody to the General Legal Council. It's not the first time. I don't think it's even the second or the third time. It happens. I mean, the Chief Justice or the Office of the Chief Justice is the overall supervisor of this whole the judiciary and by extension the profession of which we are all proud members. So when anybody, including the Chief Justice, believes that something has been done or a conduct has been exhibited that may violate any of the code of ethics, the provisions of the code of ethics and the regulation, I think both he and any other person who has the authority to do so may be permitted to do so. Remember, there was one case against a High Court judge, which the former Chief Justice raised the issue for his removal. And he went up to the Supreme Court. The argument was that, it has to be a person who reports to the president or petitions the president, and then it is referred to the Chief Justice, and that it was wrong for it to emanate from the Chief Justice to the president and back. The Supreme Court said the Chief Justice is also a citizen of Ghana, who, if she also believes that any conduct of a judge may violate his oath or the clear code and the regulations and the law that bind them, then the Chief Justice, as anybody else also, could also petition the president.
Right. So, the Chief Justice is just as a citizen as all of us.
Yes, and I don't think the Chief Justice is a member of the disciplinary committee.
Yes, that's true, but he is the chairperson of the General Legal Council.
That's right.
Can people be convinced about the fact that, yes, he's not going to be a judge in his own course? Because that's what people are saying. You refer the matter to the disciplinary committee of a council that you chair, overall superintendent.
Well, that's what the law says.
How is Dr. Ayine going to find justice? Is what is the $1 million question.
Yes. It's a genuine point someone may raise. But then the law has been very consistent now. I mean, a reasonable man does not have a reasonable fear that even a prejudiced mind will give a decision against him. Whatever it is, that is what the law says. You have to appear before a council, a disciplinary committee of a council of which you are, which binds a profession that you are a member of. It doesn't disqualify the Chief Justice. Of course, you have to submit yourself to that body and put across all your viewpoints, defend yourself vigorously if you so wish. There have been instances where after the decisions, I think you mentioned my own good friend, Mr. Sosu.
Yes.
The High Court has even set aside the decision of the disciplinary committee. And so it is not as if even their decision is a final decision, judicial. It's not. So it is important that we express some apprehension, but at the same time, you are also fortified. And I say that, look, if ever God gave us a gift, then he gave us the gift of judges who are bold, fearless, independent. And in fact, when Mr. Sosu's decision was given by the High Court, a lot of people expressed a view that tended to confirm that our judges are very independent, because you may not have expected a High Court, and people were wondering what a High Court judge can do with a decision. Of course, the word "dare" may even be used. A decision of the disciplinary committee of a council. I mean, where Supreme Court judges are on it as well. Some even said that it may not have been proper that a High Court judge will set aside a decision of a disciplinary committee made up or chaired by a Supreme Court judge. Yeah. But as we know, the decision stands. I think it was not even, it has not been set aside. Sure. So let's continue to have confidence. Where the law has provided processes by which we must follow, we must do so. In our view, even if you fail, there are hierarchy of tribunals, including the courts, that you can at least ventilate your point and then get a decision that, at least if you doubted the justiciability or the justness of the first one, you may get what you want, even as some may think that the council, the disciplinary committee may be too strong. Our judges have shown that when it comes to justice, they just determine matters based on the law, the facts, the oath they have taken, their own conviction, and believe in God.
Right. I will want us to go back to something Dr. Ayine said, in perhaps trying to justify his assertion that he doubted the independence, because like you said, he laid the foundation and there were a number of things he said. But before that, let's look at some statements made by Kwesi Prempeh. You said he was a participant on the show. I just want to know, I just want to know what his reaction was. You said contemporaneously you came out like that. He obviously has a contrary view. So definitely, I don't think he would necessarily have raised a point of order. But did he have anything to say when you came in to say that was something that was inappropriate? We have the audio of Kwesi, but we'll play it.
I don't remember that any of them reacted. It was rather Mami Mensabos, I'm sure that's her full name, who also raised an issue and said, Doctor, I think that you may have to substantiate this allegation.
Very well. Sorry to catch you, but I think we have on the screen the comments posted by Kwesi Prempeh on his Facebook page. He's asking the question, so now members of the Ghana Bar cannot offer a personal, unflattering opinion of the judiciary on an academic, a civil society, or other public discussion platform, even after a case has been decided, without risking being hauled before the disciplinary committee of the General Legal Counsel. Then he asked, really? So obviously he is, coming from the stock that says, well, this should not be encouraged.
Well, as I'm saying that everybody is entitled to their viewpoint, but then it should not also be portrayed that our judges or the authorities are averse to criticism. That has never been the case, and that is not the case in the instant matter we are discussing right now.
I'll read further what he posted, and then the various points he raised will be interrogated. It goes on to say that on the same platform where this lawyer expressed the opinion that has earned him an invitation to appear before the disciplinary committee of the legal professions regulator, other panelists, including other lawyers, strongly disagreed with him in his opinion of the judiciary regarding the case under discussion. Goes on to say, let me see if I can pick it up from here. In other words, okay, it goes on to say that, with some praising the court's handling of the matter. In other words, the platform on which the lawyer spoke was a veritable marketplace of ideas and opinion, with panelists debating each other in frank, open dialogue. And this, incidentally, was a webinar discussion organized by CDD Ghana in collaboration with the KNUST Law Faculty as part of a new judicial review series. He explains that's a partnership between CDD and 2 law faculties in Ghana that aims to review and examine the decisions of the courts for their impact on democracy and good governance. This particular panel, which examined the recent Ghana election petition through a comparative lens, featured 2 foreign participants from Kenya and Zimbabwe, 4 Ghanaian lawyers, and me, that's him, that an opinion expressed at such a forum to contestation from other participants would cause anyone to lodge a formal complaint with the Disciplinary Committee of the General Legal Council is unprecedented, bizarre, and ill-advised. Not only is this bound to have a chilling effect on the free speech rights of lawyers, it will also impact negatively on both academic freedom and the freedom and ability of civil society to promote judicial accountability, including through projects like the Judicial Review Series. Then he goes on to conclude, I find no justification whatsoever for the Disciplinary Committee of the Ghana General Legal Council to be brought into this matter or to investigate Dr. Dominic Akuritinga Ayine for the opinion he expressed on the panel. It cannot be okay for a lawyer to praise a court for its handling of a matter, but an act of professional conduct or contempt of court for another lawyer to express a contrary view on the same court about the same matter. Quite some strong opinions there.
Well, I mean, as I said, I mean, he's entitled to his view, but let the impression not be created, and we cannot repeat it more than we have done, that anyone, the authorities or all of us, are against a critique or an act of criticism of the decisions of the court. I mean, as we say, all the time that we file an appeal, sometimes you even say aggrieved by the decision of the court. Some judges prefer dissatisfied, but we still use the word aggrieved. Yes. Sometimes as it pleases the court. So you are clearly showing right there your dissatisfaction with the decision of the court. And that, in my view, should not be stretched to the point where we are saying that because of this, our judges or the authorities are against criticism. You see, no one relishes in another, or he himself being invited to the committee for investigation. No, I mean, I can't imagine that even the very people who have invited Dr. Ayine glorify that act, or are happy to invite lawyers to, but I mean, invitations are extended all the time. And I wish that...
And due process will have to be...
Yes, but I wish that, of course, one wish that it had not come to this in terms of what has engendered it, but it has happened. He's been given previous opportunity. I mean, we know what went on in the 2012 presidential elections, and what Sir John, in his soul rest in perfect peace, went through, and his friends, Ken Crunchy and so on. This time, it didn't happen like that, even though some believe that they were similar in nature. The authorities now are very friendly. I mean, you see how opportunities were given us to comment right after the court, and you were not expected to just praise them. There was some room for some criticism of how people understood it, both in the English and the Twi language, for example, until some persons, in the view of the authorities, crossed some red line. They were invited. Even at that stage, a plea, we understand, was put in for them, and they were asked to go. So perhaps they also believe that they have a law to enforce. And if they don't enforce it or are not seen to be enforcing the law, then they would have also violated the law themselves.
Right. But and like you said, it doesn't end at that.
No.
There's a right of appeal.
Yes,
and
that is if a decision is given against you, there's a right to go to the High Court. But I'm saying that I strongly believe that what happened to the other colleagues where they were discharged, even at the early stage, I think that if Dr. Ayine believes that this was not a statement that is consistent with his nature and that he shouldn't have made it, I believe that he understands that the proper steps to take in order that the situation may also end at the earliest possible time. Because when he's a member of parliament, he doesn't have time. Well, he has to travel far and near, even to his constituencies. And you can imagine that on a Thursday, you may have to be in parliament with this almost so-called hang parliament, and you may have to appear before the council. I think that there's more opportunity for him to ensure that perhaps what he did earlier on, that endeared himself to the authorities, may be the same approach he may adopt if he does not stand by what he said. But of course, I also like people to stand by what they say and face the consequences for it, so that at least, the world will also know that you're a man of your words.
Exactly.
Unless he believes, as I do, that he erred.
In the heat of the moment, like you said.
Yes.
But you see, it's interesting that, perhaps not even interesting, that it's quite significant or worthy of note that the letter referring the matter made reference to that earlier incident. And so it's like, yes, we already have you on account as having done this, and then this comes in. So that first time incident is likely to play a major role in whatever decision, and this isn't to prejudice anything,
yes.
But indeed that is a fact. But Senior, let's look at this as well. The letter says that His Lordship the Chief Justice therefore finds his alleged disparaging comments totally unacceptable and would like you, that is the disciplinary committee, to investigate this matter further. So perhaps there's an opportunity for Dr. Ayine, if he has any evidence of that compromised independence, then he has that opportunity to present it.
Exactly. I mean, it's your right to be heard and be offered adequate opportunity and facility to be heard will apply as it applies to all other instances. So the people there, mostly lawyers, Supreme Court judge or judges, and so they understand these things. I don't think that anybody will be out there with a prejudiced mind. It's a referral, it means there's a complainant, and there's a person against whom a complaint is made. The reason why I'm saying that it is perhaps better for appropriate steps to be taken so that possibly what happened to our other colleagues will happen is that, as long as these matters are on your neck, your name and your complaints are online, perhaps you may be lucky some international organization or even an internal organization or domestic organization wants a lawyer. People shudder. These days they go there, they shudder to take a lawyer who is facing disciplinary committee charges. So it's very important. And for a member of parliament, I cannot say it more than I have.
Sure.
It is very important that appropriate steps are taken, perhaps to benefit from the magnanimity that was shown our other colleagues. And if possible, let people see that there's some there may not be the need to let me put it, let me leave it there, but then,
right.
Whatever happened to our colleagues who were discharged, I think he may contact them. Maybe perhaps if he doesn't stand by it, then it may end and or be truncated as early as possible for him to also benefit from that show of mercy and magnanimity.
Sure. Let me announce quickly, though, that we were expected to be joined by the Honourable Member of Parliament for Medina constituency, the Honourable Francis Javier Sosu, who himself was at some point at the General Legal Council and had, successfully was able to get the decision of the General Legal Council overturned by the High Court. So indeed, we would have loved to have his perspective on this issue. We're trying to reach him, but we're not getting through. We'll do our best to continue. But in the meantime, we're having a great discussion here with lawyer Yao Opong. Now,